Welcome. This presentation is available for MCLE self-study credit. If you would like to receive credit, you must take 3 actions. First, click Show More text below on our YouTube page. The text will expand and show a link to download the handout materials. Once you finish watching this presentation, please click the quiz link to receive self-study credit. Once the quiz is successfully completed, you will receive a certificate via email within 72 hours. We hope you enjoy the presentation. Thank you. So without any further ado, it is my pleasure to introduce our fantastic speakers today. I'll begin with Debra Bogaards. Debra is a seasoned mediator with over 5 years of private mediation experience and almost 30 years as a mandatory settlement conference officer in San Francisco and Marin counties. She holds a remarkable track record of a consistent settlement record of over 98%. Having gained a balanced perspective after representing both plaintiffs and defendants throughout her 40-year career, her expertise includes a wide range of employment issues, personal injury matters, elder neglect and abuse, landlord-tenant disputes, and sexual harassment and sexual assault disputes. Ms. Bogaards is known for her warm yet direct approach, combining compassion with a no-nonsense attitude. Renowned as a quick study in mediation, her success hinges on meticulous pre-mediation preparation and a commitment to ongoing support, ensuring resolution even after the initial hearing. So thanks so much for joining us today, Debra, and lending your expertise to this program.
Thank you, Katie.
Next, I have Peter Linn. Peter brings nearly 30 years of legal experience to his role as a mediator and arbitrator, specializing in business, construction, employment, insurance, personal injury, and professional liability disputes. Having navigated complex litigation matters in state and federal courts, Peter possesses a profound understanding of the intricacies involved in resolving disputes efficiently and effectively. His unique background as a seasoned litigator and mediator equips him with invaluable insights and strategies to facilitate successful outcomes. With a commitment to creative problem solving and a track record of mediating diverse cases, Peter is well suited to guide parties through challenging disputes, offering fresh perspectives and fostering constructive dialogue. His dedication to helping parties find equitable resolutions underscores his reputation as a trusted and skilled neutral in the Bay Area legal community. Thanks so much for joining us today, Peter.
Thanks, Katie.
And finally, we have Ed Weiss. Ed is a highly accomplished attorney with over 30 years, also of diverse legal experience, and is renowned for his expertise in mediating and arbitrating matters. Since 2021, he's committed his full attention to dispute resolution, also volunteering as a mediator for the Los Angeles Superior Court. A former federal prosecutor, a trial lawyer, and business leader, Ed has excelled in antitrust, business, employment, entertainment, consumer protections, and intellectual property, real estate, and securities laws. His extensive background includes an 18-year tenure overseeing litigation as in-house counsel for Ticketmaster, the last 11 of which he was general counsel or chief counsel, where he played a pivotal role in navigating complex litigation, safeguarding proprietary technology, and helping to resolve difficult issues. Thank you so much for joining us today, Ed, as well.
Thank you, Katie, and good morning, everyone.
And without any further ado, I will leave it to you, Peter, to get our presentation underway here.
Okay. So I've got the first subject that we're going to cover today. I've got 2 subjects. One's mediation confidentiality cross-jurisdictionally, and also a look at Evidence Code Section 1129. Conventionally, we've thought of confidentiality in the mediation within the context of 3 separate buckets, if you will. The rules we have that are set by statute that involve confidentiality, confidentiality within the mediation process. By that, I mean the process of mediating itself is considered to be and deemed to be a confidential process by which nothing that's said or done is to be communicated with outside the context of the proceeding. And then finally, confidentiality as to a specific piece of information between the parties. As we all know, it's not uncommon. A party will share the piece of information with the mediator and ask that that information be kept between the mediator and that party. So it's kind of a subset of confidentiality. That's how we sort of view mediation confidentiality in California. But what we've seen is there's a prevalence of remote mediations, and we're finding attorneys appearing and representing parties across state lines. And that in and of itself creates certain issues that could be traps for the unwary. So I want to talk a little bit about that. The extent of confidentiality in a remote mediation depends on things such as where is the case venue? Where is the mediator located? And most importantly, which confidentiality rules apply? You're going to find that in different states have different rules. Some are more lax, some are more stringent. For instance, in California, we operate under California Evidence Code, Section 1119. 1119 is probably one of the most comprehensive confidentiality provisions within the country. Some have come close to it. None have truly adopted it. Basically, anything done, said, or written before, during, or after a mediation is done within the context of a mediation, and it's inadmissible except in non-criminal proceedings. So, in other words, evidence of anything said or any admissions made during the mediation, or in fact, during a mediation consultation, which would include pre-mediation and post-mediation communications, is not admissible or subject to discovery or disclosure, as the evidence cannot be compelled in any civil proceeding, again, other than a non-criminal proceeding. Likewise, no writings prepared for the purpose of or in the course of the mediation or in the mediation consultation are admissible or subject to discovery. Those are the rules we all know of, and we've lived by them. Essentially, all communications, all negotiations, all settlement discussions by and between the participants in the course of a mediation, as that's been broadly defined, shall remain confidential. That's 1119. Bottom line is, in California at least, the policy is to encourage people to share information within the mediation to try to compromise and resolve disputes, and they do so by making those communications strictly inadmissible. The reason that's done is that the parties need to know that their efforts are not going to be used against them at some later point in time, something that's said, something that's written, something that's conveyed. They have to know that the proceeding itself is going to be strictly closed and that they can speak freely. And with that, hopefully, the mediator is able to find a solution to whatever the problem may be. Contrast that with the federal court. Federal Rule of Evidence 408 limits the use of evidence of a promise or an offer to compromise or a claim, but it doesn't do much else. In fact, nowhere in the federal statute does it even mention confidential or the word mediation. It is strictly a procedural tool by which a federal judge can keep out evidence that it deems is going to be not relevant, and that not relevance is anything that tends to prove or disprove the validity of a claim, or tends to prove or disprove the amount of a disputed claim. Those sorts of things are not admissible in federal court. Again, no mention of mediation, no mention of confidentiality. It simply just shuts the door on those things coming in. So, for example, promises, offers, acceptances, anything in which valuable consideration is being offered in compromising or attempting to compromise a claim isn't admissible. Any conduct, any statements made during the compromise negotiations about the claim, likewise, not admissible. Certain limited exceptions, one of which would be in a criminal case, it would be admissible. But likely that doesn't usually occur. So the federal rule, while there is a rule of evidence on the subject, it is not in any way as close to the breadth of Evidence Code 1119. A couple of other examples. There are 12 states that have adopted the Uniform Mediation Act. And I'm going to give those to you because in case you're doing work or handling mediation in one of those cases, those are Georgia, Hawaii, Idaho, Illinois, Nebraska, New Jersey, Ohio, South Dakota, Utah, Vermont, and Washington. The Uniform Mediation Act is generally finds that or holds that mediation communications are confidential, but only to the extent they are agreed to by the parties or otherwise provided by state law. So if the state specifically in which I just mentioned has a more restrictive rule, that would apply. But otherwise, under the Uniform Mediation Act, the parties themselves it's just up to them to be able to come up with an agreement as to what is confidential and what is not confidential. One of the things I'm not really fond of as far as that act goes is that confidentiality can be waived in a whole number of instances, and there are a lot of exceptions to the privilege of confidentiality. For instance, if there's an agreement, the parties can waive confidentiality if it's being offered to prove or disprove a claim of malpractice. So, for example, something that occurs within the mediation, which a party may then use as a basis for a malpractice claim against the lawyer, that is accepted, and that could come in those states which have adopted the Uniform Mediation Act. As I'm going to talk about a little in my next session, California obviously does not have that rule. Other examples, Florida makes all mediation communications confidential and provides a mediation process. The parties gives them a privilege to refuse to testify and to prevent any other person from testifying about the mediation communications. But surprisingly, the only thing that is not covered is the mediated settlement agreement itself. That's not privileged unless the parties agree otherwise. Texas has adopted the Texas Alternative Dispute Resolution Statute. That one provides that a communication relating to the subject matter of a civil dispute made by a participant in an alternative dispute resolution procedure is confidential, is not subject to disclosure, and may not be used as evidence against a participant in any judicial or administrative proceeding. That's one is probably the closest to 1119, the one we're most familiar with. But again, that's just in Texas. Contrast that with New York. To my knowledge, New York does not have a statewide mediation confidentiality statute. There are no common law or statutory confidentiality protections within the state. All of it is governed more or less by local rules and confidentiality agreements. So those are just a few examples, but they vary from state to state. Which one is going to apply? Depends. If you've got a situation where you've got a mediator in California, but the case is venued in New York, the state where the mediation communications are made will likely control. For instance, that would be adopted into California, not necessarily New York. However, word of the wise, if there's a dispute, your forum state judge is going to be deciding the issue. And they may simply want to apply their own state laws as opposed to the rules that apply where the mediation is actually taking place. My suggestion for best practices, you need to address the issue up front with the mediator and all parties so as to avoid any disputes down the road. If you're in California and you are considering a mediation in another state other than California, look into the rules concerning mediations for that state, especially confidentiality, before agreeing to do so. Don't just naturally assume a comprehensive confidentiality protection exists as it does in California. As we know in federal court, there isn't any confidentiality. It's just an evidence issue. And that would be true nationwide. Local rules can change that as well. But check with the mediator and don't accept the fact that the mediator says everything is confidential. Know what state law is in that particular area. Don't blindly sign confidentiality agreements also, because you may be gaining or losing confidentiality protections for your client. Be thoughtful about drafting it itself. To the extent that you are familiar enough with California's rules, you can adopt and try to adopt the issues in California and those protections that we provide. Again, my sense is that California is probably the most stringent. So borrow from it liberally if you can. Provides you with the best protections. And understand that some judges in certain jurisdictions may not honor the agreement itself. So be careful in making sure that the agreement provides the protections that you need. Spend some time on those things and be prepared to deal with the situations as they come up. Ed, Debra, do you have any thoughts?
I have a question.
Yeah.
What happens if you have a pre-filing mediation in California and then the case is subsequently filed in federal court?
I think that it would be one where the California rule would be applied. I think that that's one where, as you go into it, I think it's important for the parties to perhaps in their agreement refer to and mention 1119, actually the entire evidence code section as it relates to mediations, and say that the mediation process is going to be conducted under those particular provisions. Anything else? Do we have any questions from the group?
We do have several questions for you, Peter. So I think there are some good ones to address at this point. Can you or can you not waive confidentiality in a California mediation? What's the definitive answer?
I don't think you can. The 1119 refers to the confidentiality in the form of shall. It shall be inadmissible. And in other words, they're not giving you the option. It is confidential. I don't see that a court is going to not look at the plain reading of specifically 1119 and say that that is mandatory, that the legislator specifically intended for this to be confidential. So I don't know that there is a way to opt out of that. And I don't know that there would be a reason that anybody would want to, unless somebody's got a reason for that.
Another interesting one that relates to your practice as mediators. So if the information is provided to the other sides, even if they cannot use the evidence, they can follow up and discover it non-confidentially. So how would you avoid that?
There's no way really around that. And that happens oftentimes with experts and expert reports and those sorts of things. Those will eventually be discoverable. There's no way around that. Probably the best practice would be to cloak it within the mediation context and identify on the document that it is a mediation communication. That can prevent that particular document from coming in. But to the extent that that forms the basis for an expert's opinion or for a factual basis for something, ultimately, one way or another, that information is going to come in because it's going to be important to the case. So it has to be produced in some form.
So I would add to that is I agree with you, Peter. Sometimes there's a reason that the party will say this is for the mediator's eyes only, which happened to me yesterday. You can share the content of it, right? So you can verbally share with the opposing side. In my case, it was the content of a chart with significant numbers for settlement, but don't give them the physical copy of the document.
Yeah, that's another way around it. They can see the contents of it. But again, typically that information is of significant importance to the case. So ultimately, one side or the other is going to want to get that information out, or it will ultimately just get out. There's just really no way around it. But again, the point of showing it during the mediation context is to have the impact to be able to drive the parties towards a resolution. So there's no harm in actually producing it within the mediation context if it's ultimately going to have to get produced anyway at trial.
And one more question before we move on to the next segment, kind of a two-part question. Do you have any examples of multi-state Zoom mediations you did? And would an attorney with a client doing business in several states want to have an attorney advise of the confidentiality in those states, or is there a way that they can research that on their own?
I would start with the latter part. I think that I would have the local attorney research it for you, because I think that having that local flavor and understanding of what exactly it is that particular jurisdiction does is going to be useful. Again, if the issue comes into a dispute and you end up in front of a judge within that jurisdiction, you want to be able to at least talk the language in terms of what that the mediation privilege that you invoked and why, and that it showed that it in fact complies with that particular state or that particular jurisdiction. And I lost the first part of the question.
Have you done any, multi-jurisdictional mediations where this question came up?
No, not the specific question came up, but I have had multi-jurisdictional cases, mostly because the ones that I've done have been involved with California, more or less California-related cases, where everybody was in agreement that California rules would apply, since again they are fairly stringent, and it does everybody. I think everybody looks at that as being a positive. The way that 1119 is written provides the greatest protections.
Mm-hmm. Great. All right, let's move on to our next section here.
Okay. Give me a second. All right. Next area I want to cover is Evidence Code Section 1129. As of January 1st, 2019, California attorneys have a statutory obligation to disclose certain information to their clients regarding mediations before agreeing to mediate the case. Unfortunately, 1129, although it is well written and well thought, it does raise a couple of ethical questions and creates, in my mind, ethical obligations for the attorney. What I want to talk about now is what are those ethical issues? How did they come about? And then most importantly, how to try to avoid them if you can. For many years, as we know, statements and conduct regarding mediations have always been inadmissible for any reason except in a non-criminal matter or in a non-criminal matter. Cases that were testing the admissibility of whatever occurred during the mediation most typically were occurring within the context of legal malpractice cases and misconduct by the attorney that occurs during the mediation. A number of cases had looked at it over time, but it wasn't until the Cassell case, Cassell versus Superior Court, that the California Supreme Court finally piped up and explained what they are, that the information contained or information received during the mediation, to the extent that it creates a situation where the lawyer has erred and it cannot be formed the basis for a malpractice claim. Cassell involved a situation involving discussions in a pre-mediation conference between Cassell and his lawyers. And during that conversation, they had agreed that at no point and in no way that the plaintiff's attorneys would accept less than $2 million for the trademark infringement claim. The mediation took place, and it went on for a number of hours. And after the 14th hour, Cassell started feeling ill, and he wanted to go lay down for a period of time. So his attorney said, "That's fine. We'll call you back as soon as we need you." When the attorneys did call back, however, they had negotiated a deal that was far less than the $2 million. It was actually $1.25 million. Understandably, Cassell was not pleased with that outcome. He ultimately sued his lawyers, alleging that they forced him to accept the $1.25 million settlement rather than the higher amount. And he claimed during the mediation that his attorneys had threatened to abandon him on the eve of trial if he didn't agree to settle the case for that amount of money. Understandably, as I would have expected, the attorneys in the malpractice case filed motions in limine to exclude any of the evidence that was of the malpractice from the mediation itself, and the trial court granted it. So there was no evidence of what was said or done within the mediation or pre-mediation conference for the jury to consider. The Court of Appeal granted a writ and held that the mediation confidentiality did not apply to mediation-related communications between Cassell and his attorneys outside the presence of the mediator or any other of the opposing parties. The reasoning was that private conversations between an attorney and client were not communications between disputants within the mediation. And so those communications themselves are not protected by confidentiality. California Supreme Court took it up, and they quickly reversed. They looked at simply the plain language of 1119. And the plain language specifically says that no evidence of any of these conversations before, during, or after, and this is where we get into the pre-mediation work, is admissible for any purpose. The court went on, and I think adopted what California legislators always wanted, is mediation confidentiality statutes overall serve the public policy of encouraging resolution of disputes. And the statute is designed to provide the maximum protection for the privacy of those communications within the mediation context. And they did not want any of the district courts, or district appellate courts, to making their own separate rules, which flew in the face of both public policy and the plain language of 1119. Shortly thereafter, after that decision came down, so in other words, that effectively cut off any malpractice claims that could occur during the mediation process. California legislature stepped in, and after a 5-year study by the California Law Revision Commission, they finally started making recommendations in 2017, and they were trying to find an exception to the mediation confidentiality. They compared it sort of like Evidence Code Section 958, which allows certain evidence in during malpractice claims. But their proposed rule was that evidence is relevant and therefore admissible if it proves or disproves an allegation that a lawyer breached their professional obligation when representing a client in the context of a mediation or mediation consultation. Understandably, a lot of lawyers were not happy with that proposed rule. Ultimately, that rule was rejected entirely and led to Senate Bill 954. That bill was intended to take a more measured approach to address public policy, to strike a balance between the needs of the client in a situation where conduct may have risen to the level of malpractice and the public policy behind encouraging confidentiality. So 954 was enacted in 2019, codified in Section 1129. What 1129 effectively does is it requires certain disclosures to a client regarding a mediation that must be made either prior to agreeing to mediation or as soon thereafter as possible. The statute provides that the disclosures have to be made in a single, standalone document, 12-point font, and it has to be signed by both the lawyer and the client. The consequences of failing to comply with this provision cannot provide a basis for either setting aside or voiding a settlement, nor can it provide the basis for a malpractice claim. But it can lead to disciplinary actions by the state bar. I'm not familiar with any time that the state bar has taken action against an attorney yet on that, but it does. That is the remedy for a client if they haven't received this. And 1129, the form itself is actually in 1129. It is something that can be simply cut and paste by most lawyers or most firms into a letter and provided to the client, and it should be done so at the point in time when the matter has been, the person has been retained for that particular matter. The first part of the disclosures is simply a recitation of California law. All communications, negotiations, or settlement offers in the course of mediation must remain confidential. Statements made and writings provided in connection with the mediation are not admissible or subject to discovery or can be compelled by compelled disclosure in a non-criminal proceeding. A mediator's report, any opinions, any recommendations or findings by the mediator that occurred about what occurred during the mediation also cannot be submitted to a court. And finally, a mediator cannot testify in any subsequent civil proceedings about any communications or conduct that occurred during the mediation. No problem there. The last one is where the problem comes in. Specifically, it says all communications between the lawyer and client made in preparation for a mediation or during a mediation are confidential and cannot be disclosed or used except in very limited circumstances, even if the client later decides to sue his or her lawyer for malpractice because of something that happens during the mediation. That creates a problem. Specifically, let's see, it goes to Rule 1.8.8 of the California Rules of Professional Conduct. That particular provision states that a lawyer is prevented or prohibited from contracting with a client to either prospectively limit the lawyer's ability for professional malpractice or settling a claim or potential claim for professional malpractice unless the client is represented by independent counsel or has been advised in writing to seek the advice of counsel and is given the opportunity to do so. We're all familiar with that rule. So the way, when this issue was raised in front of the drafters of the 1129, their response was, well, we've only carved out an issue with specifically the within the context of the mediation. There isn't any reason 1.8.8 doesn't come into play outside the context of the mediation. And since public policy, in our view, is greater than that rule as it relates to what a lawyer can and can't do regarding limiting their exposure, they felt as though the rule itself, by simply providing the notice to the clients that no claim of malpractice can arise out of the mediation-related conduct, that was a narrow enough exception for 1.8.A to not apply. I disagree. I think that the rule 1.8.8 is meant to be across the board. I don't know that the 1129 reconciles that issue. I still think that creates a conflict of some sorts. But then the issue becomes even more muddy because Rule 1.7 provides that a lawyer shall not, without informed written consent from each affected client, and for those of you who represented or represent multiple clients in a particular action, you have to get informed written consent from them, usually when there's a situation where there could be a conflict that arises. That conflict could be between clients. It could be a conflict between a client and a former client or a third person or the lawyer himself. And that's where you run into the issue. Informed consent means the lawyer has to communicate and explain all of the relevant circumstances and material risks, including the actual reasonable foreseeability of an adverse consequence of the proposed course of conduct. So when the disclosure is made under 1129, the 1129 does not require the informed written consent to allow the client to go and seek independent counsel to decide whether or not they should or should not mediate the case. What it does is that the lawyer is simply acting in their own self-interest by telling them that they are receiving, that they're getting, going to mediation. There will be, well, let me start again. By agreeing to mediate the case, the client cannot sue the lawyer for malpractice, regardless of how egregious. In doing so, the attorney has clearly an interest in having the client sign the document and acknowledge the disclosures because the attorney doesn't want to face potential liability for what occurs during the mediation. That in and of itself creates the conflict because the attorney is now doing something in their own self-interest, but not in the same time, not requiring the client informed written consent. So in other words, the client is simply reading this. They may or may not fully understand or appreciate it. but they are not given the opportunity to have independent counsel review that and tell them, should I sign this or should I not? Whereas in every other instance where there could be a potential conflict between the lawyer and the client, that has to be explained, and that also has to get informed written consent. 1129 doesn't do anything with that. So arguably, the solution is simple, but it's not necessarily something that the legislature is going to do. The way to handle this is within the agreement itself, is simply add a sentence or a paragraph in the disclosure that contains language stating that the client understands the disclosures, that a potential conflict of interest could arise if the case is mediated, and again, specifically identify what does that conflict look like, and that they're waiving the potential conflict after having been given the opportunity to seek the advice of independent counsel. I think the idea would be that most independent counsel would recognize that, yeah, while there's that risk, that risk as weighed against not trying to resolve the case through mediation is probably not something that an attorney would say, yeah, that risk is too great. That way, if you have the statement in the disclosure that says you've given them the opportunity to at least consult with outside counsel, you avoid both the disciplinary proceedings actions that could occur from the state bar by not doing the disclosure, and also you've complied with the ethical obligations that go along with providing the informed written consent. So while I think that 1129, I think skirted the line of still allowing mediations and mediation conduct to not be used as a basis for attorney malpractice claims, it nonetheless still creates ethical issues that need to be dealt with that are not addressed in the statute, but can be easily rectified by most practitioners. Debra, Ed, do you have any questions or thoughts?
I think that's excellent, adding that verbiage. I also think it goes hand in hand with something I love to see, and that is a pre-mediation conference between the attorney and their client, whether it be over by Zoom or in their office. So in addition to managing your client's expectations for mediation, you've also discussed this with them verbally, and then have, of course, the signature. And I think that tees it up for a really successful interaction at mediation.
Well, the one thing is that my sense sometimes is that in having that discussion with the client, it sometimes may raise a red flag with the client. And I think you're right that having that conversation and explaining this in as much detail as you can provides them probably with a little bit more, a better feel for what's going on, and that they understand it. And then hopefully that the lawyer doesn't do something within the mediation context that gets them to rethink whether they should have signed the agreement. But I agree that the pre-mediation phone calls is important, and also the disclosures themselves.
I have a question, Peter.
Yeah.
That was excellent, including your suggestion. What does 1129 mean for those of us in this webinar who are neutrals, or is this merely for the attorneys?
It's for the attorneys alone, but I know that a lot of mediators provide the verbiage to their prospective attorney clients to simply say, here, make sure you get this out. If you have any questions, give me a call. I don't know how familiar with practitioners, younger practitioners in particular, are with 1129 and what they have to do with it. And I think that it might be incumbent on the mediators to say, oh, by the way, don't forget to send out the letter. Don't forget to get it signed. Obviously, this is for your protection. If you have any questions, let me know. Otherwise, just make sure that you got this in your file. And if they have questions about it, especially the ethical issues that come up, I think it's worthwhile mentioning to them so they can craft their agreements in such a way that it complies with their statutory obligations as well as their ethical obligations. Katie, are there any questions out there?
We had one relevant particular question on this. If an attorney is representing a client in multiple ongoing matters, do they need a separate disclosure for each of those cases?
To be safe, I would say yes. I think that it's not necessarily client specific, it's case specific. So for each case that they, to the extent that, I mean, not all cases will go to mediation, but out of an abundance of caution for each matter that is being handled, I think it's best that the attorneys get them from every client.
Mm-hmm.
That was my practice, and that's my recommendation.
Mm-hmm. And does it apply to mediation ordered by a federal court?
I don't think so, but again, out of an abundance of caution, again, in the federal rules of evidence, don't talk about confidentiality, and they don't talk about mediations in 408. So it's probably best to go ahead and send this out to the extent that the parties are going to have the federal case be operated in a mediation, which is at least governed by California's mediation statutes, then it should go out as well. But that might be a closer call as to whether, just out of an abundance of caution, I think it should go out.
Great. All right. Well, let's move on to our next section with Debra Bogaards on settlement agreements. Thank you, Peter.
Welcome.
Yeah, you did an excellent job, Peter. You're a hard act to follow. So following through with your case site, Cassell versus Superior Court, which holds that the confidentiality protections extend to attorney-client discussions related to a mediation. Then the next question is, what happens when you reach a settlement and mediation, which of course is what we mediators like to see? When those settlement terms are reduced to an agreement, is that confidential? So for that, we have Evidence Code section 1123 to look at, and it makes settlement agreements inadmissible unless any of these conditions are met. First, the parties make it clear that the agreement is admissible or subject to disclosure, and that easily can be put into your settlement and release agreement as one of the terms. Secondly, the agreement provides that it is enforceable or bindings or word to that effect. Again, something you can use as a drafter. 3, all parties to the agreement expressly agree to its disclosure. And 4, the agreement is used to show fraud, duress, or illegality. So the practice tip from here is, for clarity, just go ahead and waive section 1123 in the settlement and release agreement, and then you can add in some other language as well, and that should cover it. So a question often asked is, when is the mediation over? Obviously, when you have a fully executed written agreement. One of my practices as a mediator with ADR Services is I like to have everything signed, sealed, and delivered in that day of mediation. So typically I'll ask the defense counsel to send over a settlement and release agreement in the morning at the beginning of the mediation, so that, if you've got terms such as confidentiality or non-disparagement, which we often see, then we're not waiting until last minute or even after we have the settlement to bring those up. So you have a fully executed written agreement. That's the easy way. 2, 10 days with no communication between the mediator or any of the parties. And then naturally, there's an agreement by the parties to terminate the mediation. When I was in practice, I think I was only aware of the first step, which is a fully executed written agreement. There has been codification after this that if I, as a mediator, send out to the parties, so this will confirm a settlement at, say, $3 million, and you as the attorney write back confirmed, and the opposing counsel writes back confirmed, that actually will be an enforceable agreement. However, I think the better practice is when we have the formal settlement and release agreement drafted and is executed by all of the parties. Again, something that can easily be done with DocuSign, even if the parties are in different areas on Zoom. Sometimes they're in their car. You can easily do DocuSign on your phone. I think that's a great practice. The next topic that we bring up is lying in mediation. I know, one of our favorites. It does happen. We're all aware of that. So is it okay to lie to Ed or Peter or me as the mediator. Mark Twain had a good quote, and it's, "A man is never more truthful than when he acknowledges himself a liar. There are three kinds of lies: lies, damn lies, and statistics." So with that in mind, we have California Rule of Professional Conduct, Rule 4.1, that codifies this. It is the truthfulness in statements to others. In the course of representing a client, a lawyer shall not knowingly, A, make a false statement of material fact or law to a third person. We'll come back to that. B, fail to disclose a material fact to a third person when disclosure is necessary to avoid assisting a criminal or fraudulent act by a client, unless disclosure is prohibited by Business and Profession Code Section 6068, Subdivision E1, or Rule 1.6. So if we go to the next slide, it's kind of a fun little table of lies. So I'm going to throw this out to Ed or Peter. When an attorney gives you a bottom line or their top line, or tell you they're earnestly desiring to settle the case, is that okay? Ed, what do you think?
I think it's okay, but often I see in mediation someone gives a bottom line and it turns out that it's no such thing. I don't know, from where I sit, I think that's part of the process, and it kind of falls into the realm of either opinion or puffery, and I'm not sure it's actually a lie. I suppose it could be, but
That's exactly right. No, you're exactly right on that. It's just deemed puffery. Everyone does it. I think we as mediators somewhat expect that. You know, I usually have the rule of three. If someone tells me that's their bottom line and they stick to it 3 times, then I'll actually believe them. But as we know, that's usually part of the negotiation process.
Deborah, I also tend to think
Go ahead.
it's advocacy as well, and I don't fault any attorney for being a strong advocate for their client. I think it's important that they do so. So when we hear those, I see that as nothing more than the lawyer doing precisely what they've been hired to do.
Exactly right. The next column, authority to settle. This is a little trickier. I think it is very important, and it is a lie if you represent you have authority to settle or settlement amount and you don't. And it can get you into trouble as an attorney. So I have an anecdotal story of a neighbor of ours many years ago who was in trial. So he would leave the house every day. He was ready for trial. And then at the end of the night, in those days, if you were a defense attorney, there was a practice of writing a report to the carrier to let them know how the case is going. Expert so-and-so testified. He or she made a great witness. We think the case is really going well. The jury believes in this. Or you have a scenario where you say, gosh, you know, the experts are not doing so well. I think we're losing the jury. The case value is getting worse. So this particular attorney kept writing to the carrier every night. The case was getting worse and worse and worse. So after a couple of weeks of this, finally the carrier said, you know, maybe we should go down and watch the trial. Maybe we should think about settling it during trial. So the carrier goes to the San Francisco Superior Courthouse, goes to the department that was listed in the reports, and finds the doors are locked. The carrier learns that that case was never in trial. Now, the attorney, by the way, had been doing his billing statements for his partners of the 12, 14 hours he was billing per day for trial. He wasn't in the office. So it turns out that he had settled the case for beyond his settlement authority. He never went to trial. And he was hoping by letting the carrier know the trial is progressing, it was getting worse, they would give him this higher amount of settlement authority. So obviously he faced suspension from the practice of law, and there were so many different levels to look at. He was also preparing these billing statements, so there was lie upon lie upon lie. So the moral of that story is if you are looking to settle a case, make sure that you have the authority to settle, because that you need to be truthful about. Same thing, it's nice to have your decision makers present. Anybody else have any horror stories on that before I move on? Okay. Coverage. This is another area that coverage, solvency, bankruptcy facts that you need to be truthful. So we are all familiar with California Form Interrogatory 4.1, in which you state the policy limits. And so I mediated a case recently where we were aware of the $100,000 policy limit for one of the defendants. And then during a pre-mediation phone call that I had just less than 2 days before the mediation, the next attorney in the case found out after being in the case for 1.5 years that she actually had discovered maybe it had been misplaced, but there was an additional $15,000 policy limit. And the question she had was, well, it's probably going to sell for under the 100,000, so I don't really need to disclose it now. Well, after getting, a phone call to the other attorney involved, 4.1 was amended in the form interrogatories, and then I had the attorneys inform the other party that there was an additional 15,000 in coverage, because when you go into a mediation, you must know accurately how much coverage is available, even if the case value may not warrant all of the coverage. The same thing is true about bankruptcy facts. Oftentimes we'll have a defendant who their policy limits have been put up, but they're looking for extra contractual or money out of their pocket. And so the problem with that is when they represent in mediation their assets, even if you have personal counsel or bankruptcy attorney there, you may not have the documentation to show, what their bank holdings are or their real estate or other. And so there it is very important to be truthful and honest.
So Debra, one issue that's come up with me with coverage was I had a situation where it was an eroding policy. So trying to peg exactly how much was left when it came to, during the mediation, what was the policy limits demand going to be. I had a rough number, but it took a fair bit of time for us to actually go through and try to figure out what the coverage picture was. After the fact, I actually did receive a call from one of the attorneys saying, oh, you know what, we accidentally misstated the coverage. We've actually burned through a little bit more, so the demand, the policy limits demand would have to be less. So it does happen. I felt as though I gave that attorney a lot of props for coming forward and at least correcting, even after the fact, and saying, by the way, I don't want anybody to be under the misapprehension about what we actually have here. We actually have less, and I don't want anybody to be going around thinking there's more than that. And I, again, like I said, I felt that was very well done by the lawyer.
It sounds like it really was. All right, so we'll move on to USDC, Cal General Order number 1110 ADR. So each party shall appear at the mediation in person or by a representative with final authority to settle the case. And I know as a mediator, when we have our pre-mediation phone conferences, I always ask who will be attending. And it's really important that we know that the claims rep, for example, that will be there has authority to settle the case up to a certain amount. If the authority level is higher than his or her individual level, it's important to know that they have a lifeline to call. In other words, the claims manager will be in the office during those times, because it's important to have, obviously, enough settlement authority there. Representatives of the insurers with decision-making authority are also required to attend. And now that we do this by Zoom, I'm sure everybody on this Zoom recognizes that that's been really nice, so that we can have, when they're out of state, they are very available to attend. Lastly, each party shall be represented in mediation by the attorney who is expected to try the case. Sometimes this happens. It would be nice if all of the time it happens where we had the trial attorney in the room, but at least it's important to have all of the correct decision makers there. Peter, Ed, any experience with that?
I think we've all had the experience where we didn't have the right person in the room. And I think that happens. And sometimes it's a mistake and sometimes it's by design. But I think my practice has been, and a lot of mediators out there, is in that pre-mediation phone call is really drill down on that issue, is who will be there. Do we have the right people? Do we need coverage counsel available by phone? Do we need, for example, a client's independent counsel present if there's conflict issues? Drill down deep in those things, find those things out to try to avoid that to the extent possible.
Sometimes it comes out well during those calls, by the way, in that I had a multi-party case once where it turned out of the maybe 6 different defendants, 3 of them had the same insurance carrier. 2 of them were problematic, and the way we ended up getting it settled was the 2 that were problematic with the same insurance carrier just let the 3rd defendant and the same insurance carrier handle it. And so we took away some of the difficult personalities, and we were then had smooth sailing to get it settled. Ed, did you want to add to that?
I was just going to say, especially in some of the volunteer cases that I do for the federal and state courts, that it's unclear whether the insurance representative who truly has the ultimate authority to settle the case is really involved or really reachable. Sometimes they are, sometimes it's not crystal clear that they're fully engaged, and so sometimes it gets a little blurry with respect to that requirement.
Thank you. Okay, next we're going to move on to neutrality. So neutrality and impartiality are 2 of the hallmarks for mediators in this process. I'm going to skip over the next slide and go to what is neutrality? How does it differ from impartiality? And I'd say those are good questions. So if we were to define neutrality, it involves refraining from taking sides or expressing a preference in a conflict or controversy. It implies a stance of non-involvement or non-participation. So as an example, a mediator in a dispute might adopt a neutral position, facilitating communication between the parties without endorsing either viewpoint. Impartiality is defined as the principle of treating all individuals and interests equally without favoritism or bias. It emphasizes fairness and objectivity in decision-making. So, for example, a judge is expected to be impartial, making decisions based solely on the law and facts of the case without regard to personal feelings as to either party involved. Now let's go to the slide on mediator neutrality and impartiality. So when does influence cross the neutrality line? I'm sure that everyone in our Zoom audience probably has had maybe one bad experience with that. I'm going to throw it out to Ed and Peter. Do either of you have some examples of this?
Not personally, no. I've heard of them, but I've not experienced it.
We've all heard the stories.
Yeah, I think everybody's heard the war story about that mediator or whatever, but I think a lot of us have take that role and take those roles very, very important. I mean, it's very important to us, and try to really stay across that line.
It's very important to stay on the right side of that line, and also to provide an evaluation, but to do it in a way that doesn't put your thumb on the scale, and not do it in really in a concerted way until you're asked to do so, because you can, if you're not careful, you can do more harm than good.
That's exactly what I do. So, do evaluations of a party's case affect the mediator's perceived impartiality? And I would say that we're there as neutrals or mediators to help you settle the case. And so really that is what we were talking about earlier, the decision-making that the attorneys will bring forward. However, all of us have on occasion been specifically asked to give an evaluation. So like we were discussing with the judge as to impartiality, if you do so and you base your evaluation on the facts that have been presented and the law, I think it can be done with more impartiality. Okay. Well, I think this is the fun topic. How many of you out there see that the majority of mediations, at least in my experience, are now resolving using a mediator's proposal? Very quickly, for those people who have not yet experienced a mediator's proposal, that is when usually near the end of the mediation, let's say the parties are very polarized. Someone's at 2 million, another party's at 100,000, or well, let's say the gap is smaller. Sorry, bad example. Let's go 2 million and the other side's at 1 million. And the mediator goes into your room and says, I'd like to do a mediator's proposal. That's when I give you a number that you can say yes to settle at. If you say yes and the other party says no, then they won't learn that you said yes and it would have settled. So there's really no harm there, which is true. And so mediator will say, my proposal is to settle at 1.7 million. I think anyone can split the baby and say 1.5 million, and a really good mediator is going to have it either above or below the mean. And there are ways that mediators come up with those numbers. Most often, we do it in conversation with you. We feel you out on what would you say if we're looking at settlement in a certain range, or we start with a bracket to get to the sweet spot to a range. But oftentimes, we'll give you the number. While on Zoom, my practice is typically to give each side 1 hour to decide upon it, unless there are other factors. The carrier has asked for a few days to think about it, or they want to exchange a document. But if not, and I have a pretty good feeling it's going to resolve, I might just give 1 hour. And then you tell the parties, I'd like you to come back in 1 hour, or I'd like you to come back in 3 days by 5 o'clock, hopefully with a yes. And then your case is settled. So this is in the materials what some experts have said about a mediator's proposal. They say, I define the mediator's proposal, next slide, as the exact point in time where the mediator ran out of skills, or some mediators use it, that's it, as a tool for self-importance in a way that says, here, I'll resolve this case for you. Or could it be that if more mediators possessed a wide variety of skills and techniques, then the mediator's proposal might quietly slip away? Or lastly, unfortunately, I think many counsel looking for a mediator's proposal are more lazy than savvy. I disagree with these comments. I see as a trend that mediator's proposal have been working in, I would say, over 90% of my cases. I see them as a face-saving tool. Oftentimes, the plaintiff's counsel might consider a lower demand, but they need to manage their client's expectations. Or on the defense side, it's a way for the mediator to give a number that is higher than the settlement authority, and it might mean that they need time to go back to Bloomington or headquarters to roundtable it amongst the claims management to come up with that money. But if you think about it, mediators are selected by both sides. Some plaintiff's counsel will look at the names for mediators that are given by defense counsel, because they figure, rightly so, that if defense counsel is comfortable with this mediator, they might be able to get even more money from them. So on the defense side, when they go back saying we need higher settlement authority, they'll say, you know what? You agreed upon Peter Linn or Ed Weiss as your mediator. So obviously you respect their opinion. And when they tell you that this case, if they gave evaluation, has a higher settlement of value because, you know what, the plaintiff made a really good witness, something that they considered to be a strong element in this case, then they're more likely to get that higher authority. So I think that mediators' proposals, when done correctly, can be invaluable in a case. Ed, what do you think?
I agree with that. I just think they have to be used at the right time and used carefully. In my experience, it's important to explain to both sides at the right time, just as you did a few minutes ago, what the mediator's proposal entails, and before uh, making one, getting buy-in and permission from both sides, and with some to go forward and to make the proposal, and to do it only when there's some reasonable chance that it's going to be successful. Because in my experience, particularly in my previous career when I was a consumer of the mediation experience as general counsel for Ticketmaster, in a couple of instances, I saw a mediator's proposal that was kind of out of bounds and negatively impacted the ability of the case to settle down the road. So it's an important tool, an effective tool. It just has to be used with care.
It's a
Peter.
timing issue always in terms of when is the appropriate time. I've gotten the request very early on in mediations, and I'm always reluctant to do it. I think it makes more sense because, quite frankly, and to be honest, I don't have a sense of what the case could settle for. Ultimately, I think I get to that point, but if it's too soon, I don't have a number that I could give that I could ever explain. And I want to be able to provide a justification for it along with the number itself. So timing is the key issue for when it's appropriate. And then obviously, if I'm hearing from both sides, I'd like to get a mediator's proposal, both sides separately, both sides privately. Then obviously, then I'm getting an indication that everybody is interested in trying to go that route.
I agree with you. I see timing is usually towards kind of middle to the end of your mediation time, when it has to be when they're somewhat polarized and you could continue to do, the tit for tat negotiations or the dance or the haggle waggle, whatever you want to call it. But it might be a more direct shot at the basket at that point with the mediator's proposal. So there's all these great concerns that go into it. And as a mediator, it's usually when we have a pretty good feel for how high we can get the defense to go and how, low for the plaintiff side, but hopefully we're trying to get them the most money possible. So I agree that timing is kind of critical. All right. We're going to move on to the informed consent in settlement agreements, which is very important. Attorneys must ensure parties provide informed consent to the settlement terms. And by that, we know that their client is aware of the policy limits and settlement authority. We also have to, for the attorney, provide clear explanation of the terms. And for that, I'm thinking of any special terms like confidentiality, non-disparagement, and even more importantly, if there's a liquidated damages clause. So often we have clients and they're just lay people. This might be the very first interaction they've had with attorneys, and particularly in a mediation. So I hope that you as practitioners will spend enough time in your pre-mediation conference with your client to explain that, let's say particularly in an employment case, there will be confidentiality, non-disparagement terms. I have a habitability case now where liquidated damages are important because some of the tenants may go on to the website for the property company, or there might be a news presentation, right? And more clients join. So we, as attorneys, you have to anticipate what will happen if the deal goes south after, right? We have a signed settlement agreement. So what about enforceability of mediation settlement agreements? For that, we have California, next slide, please. California Code of Civil Procedures, section 664.6, which sets forth the requirements for entering settlement terms into a judgment. In terms of best practices, we want to ensure that the agreements are in writing and signed by the parties. We've talked a little bit about DocuSign, and I'll say it again. It's one of my favorite things for mediation You are done in a day on a case that you might have been carefully working up for 2 years. I saw a plethora of cases that were going to trial, and we were able to effectuate the settlement, and while still on Zoom, use the assistant from ADR Services to send around a DocuSign to the plaintiff, and therefore you had a closed file, which in defense terms is a happy file. Lastly, we'll talk a little bit about ethical concerns around coercion. So during a mediation, we want to avoid coercive practices. We're very aware of deal fatigue. You've been in the room or your house all day, and about 3 o'clock, the plaintiff particularly might be getting rather tired. As a mediator, I'm going to encourage them to maybe take a walk around the block and get fresh air, have some water, coffee, tea, beverages around like we have if you were to come in person, have lunch and snacks ready, because we want them to feel that even though they might be nervous in this setting, that they are going to get a settlement and we are not going to hopefully have any coercion around it. So when the mediator maintains a neutral position, then this is ultimately going to be for both the plaintiff and defendant to resolve on their own and feel strong that they were not coerced. I'm going to end. There are other relevant code sections which I've put in the materials, but due to the interest of time, I will now pass the baton. Thank you, Katie.
I do want to pop in with just 1 or 2 questions that were related to this topic area, Debra.
Sure.
One in particular, what are the cues that you look for to indicate it's time for a mediator's proposal?
Oh, that's such a great question. And hopefully we're subtle when we respond to those cues. We listen to everything that you say verbally and actually non-verbally when we enter a room. And so if I'm hearing from a party, let's say on the plaintiff side, I'll say, you know what? The other side has offered $450,000, but I'm kind of thinking that we might be able to get them to $500,000. And then on the plaintiff side, the plaintiff's counsel comes back with, no way, I am not interested in settling this for under $750,000. I've told you that before. Are you hard of hearing? Something like that. We're like, okay. So you're kind of testing the waters at the $500,000 at that point. And then we do the same thing on the defense side. We go in and we might say, yeah, you've said that you're not going to be paying anywhere with a number with a 5 in front of it. I get that. But what if, we were able to close this and they've come down off of their million and, we're going to get somewhere in the 6s. Certainly you might consider. And so we'll get cues because, in fairness to both sides counsel, you don't want to give up your hand until you're really, really closer. So you're in that sweet spot. And then all of these clues we've heard all day will become important.
I like it. Ed or Peter, any thoughts on when to pitch the mediator's proposal in your cases?
I think it's the verbal clues, it's the nonverbal clues. And hopefully we're going to get a verbal clue saying, yeah, my client is asking for a mediator's proposal. I think that's a huge cue. And then if to the extent that the other side is silent or other sides are silent, we have to test the waters, because if one side's ready and one side's not, it won't work. We have to have both sides getting on board with this.
Yeah, I think you keep your eyes and ears open. Sometimes it's a direct signal like, hey, how about a mediator's proposal? Or sometimes it's some of the cues that Debra was mentioning. And at some point, you want to just plant the seed, perhaps, and just throw it out there so they know that that's available at the right time, and maybe just explain a little bit about how it works, because not everyone is as familiar as perhaps as some others. And especially the clients want to know and hear what that entails.
Our first program this morning talked about artificial intelligence and where an AI mediator might be effective or where it might be a shortcoming. And it sounds like this is exactly an example of where that all-important human element comes in.
I think the human element, Katie, that you expressed is so important because, look, I mean, if I gave that example between one party's at 1 million, the other's at 2 million, I think anyone can do a mediator's proposal at 1.5. But to really show your strength as a mediator is listening to those cues, verbal and nonverbal, and deciding, can you do it above or below the mean and why? And usually it's like, how much more above the mean can I get? How much can I let the defense counsel stretch? And so that's where I really think it's, as all three of us have said, the verbal and nonverbal cues that we've been getting all day.
Mm-hmm. Well, in the interest of time, I'd love to turn it over to Ed for our next section here, the 8.3 mandatory reporting rule.
Okay, thank you, Katie. So the next 3 segments that we're going to cover for the balance of the program deal with increasing regulation of lawyers and neutrals. The first segment, California Rule of Professional Conduct 8.3, which was new a year and a half ago, is no longer brand new. It became effective August 1st, 2025. It reflects the increase in regulation of lawyers, and it requires, under certain circumstances, that lawyers report criminal acts or fraud, deceit, or intentional or reckless misrepresentations or misappropriation of funds to either the state bar or a tribunal that has the ability to act. I'm not going to read the entire rule. It's there for you and for your reference. But if you can you move the slide back, just Katie, thanks. Just as an overview, the first part of it explains what has to be done. The second one is a way of saying that this is a mandatory rule, as evidenced by the word shall in Section A. Section C eliminates some of the criminal acts that might have to be reported. Criminal acts that are not crimes in California, but that are committed in another state don't have to be reported. And then Section D sets forth a number of exceptions to the reporting requirement. Okay, next slide, please. This is just a very brief summary of the rule, and I'll try to explain a little bit about what each of these components are. Next slide, please. So what do you have to do? So if you have a situation where you have credible evidence that one of our colleagues has committed a criminal act or is engaged in dishonesty, fraud, deceit, or reckless or intentional misrepresentation or misappropriation of funds, need to either report it to the state bar or to a tribunal with jurisdiction to investigate an act or misconduct. And what the latter refers to perhaps is if you're in an arbitration or you're in a proceeding before in court where there's something pertaining to that case, you need to bring it to the judge's attention, or you can also report it to the state bar. There's a timing requirement. It has to be done without undue delay. And what does that mean? The answer to that is I don't know, but I think what it means is that you need to have an explanation for why you're not reporting it. If you're not reporting it, you have the ability to consider it. Perhaps consult with competent counsel, someone who specializes in professional responsibility or ethics. And also there's some judgment that is required with this. It's not just everything that you see a lawyer doing wrong or is suspicious that needs to get reported. It has to be, you have to have credible evidence. So there's or know of credible evidence. So there's a knowledge component, and it has to raise a substantial question. It's not just that someone said something wrong in discovery, or there's an argument about, when a deposition is going to take place or whether someone's available for a deposition. That gets brought up routinely to the judge or the discovery referee or the arbitrator routinely. this isn't about that. These are things that raise substantial questions about someone's fitness or trustworthiness to be a lawyer. Next slide, please. Okay, so there are a number of important exceptions. You've all come to a neutral service for your MCLE, and the first exception I'd like to mention is the mediation confidentiality that Peter walked us through in great detail earlier this morning. Next. Also, an exception is there's no requirement for the disclosure of information protected by the attorney-client privilege. Also, confidence is learned by a lawyer from a client are also a recognized exception. There is one caveat here. There, under the model rule of professional conduct 8.3, that is similar but not exactly the same as our new, relatively new California Rule of Professional Conduct 8.3. There's an admonition to seek client consent and disclosure where would not substantially prejudice the interests of a client. As we all know, it is important to keep to protect a client's interests, even at peril to the lawyer. So in this instance, it's there's a suggestion or a best practice of at least consulting with the client and asking if they wouldn't mind that you report it to the proper authority. Next slide, please. And this just sets forth the exceptions in a little bit more detail, but it's important to know that there are exceptions, and not everything that you encounter has to be reported. Are reports to the State Bar confidential? Yes, they are. However, there are, after the inquiry or investigation, if there is one by the State Bar, once a complaint is filed, that becomes public. Next, please. And that is, this slide just reinforces what is on the State Bar website, indicating that reports to the bar are confidential. However, once charges are filed, it becomes public. Concerns. There are a number of concerns about how the rule is going to play out, or how it's played out, and what could happen. There's the prospect or the possibility of abuse by attorneys who are not well-meaning and are seeking to gain an improper advantage over an adversary or someone with whom they have a disagreement. There's, as I mentioned, there also is an element of judgment in terms of when and how and what you report. And so there's some concern that some attorneys, under the guise that they are required to report this, will report something when in fact they really aren't required to do so. And also, as I also mentioned, there's a concern that Rule 8.3 could require attorneys perhaps to act contrary to the interests of their clients. The client interests are paramount, and it's only the information that's learned in the ambit of the attorney-client privilege should not be reported, unless, of course, there's a consultation with the client and the client gives informed consent. Next, please. One area of, or one source of comfort is that there are penalties for false or malicious reports. So really, if you're going to report something, you really need to be sure of what it is that you're reporting, and it can't just be on conjecture or an amorphous suspicion that a colleague of ours is a bad person, or seems suspicious, or is possibly doing something wrong. You have to have credible evidence that someone is doing one of the things enumerated by this rule. And if you make a false or malicious report, you are subjecting yourself to discipline. So is the rule retroactive? The rule itself is silent. Perhaps this was more of an issue when this first was introduced in August of last year. Now we're about a year and a half down the road. Perhaps it's not as much of an issue, but it is still, as far as I'm aware, it is still an open question about information that you may have learned, in the distant past. Next, please. So what does this mean for us in mediation? Again, there are penalties for false reports. Very important, there is a rule of professional conduct against threatening criminal, administrative, or disciplinary action. That's Rule of Professional Conduct 5-100. And also there are laws, federal and state, against extortion. I mention this because it doesn't happen a lot, but I do in my travels as a mediator hear, well, you know what? Tell him in the other room I'm going to report him or her to the state bar. And the answer to that is, you can't threaten someone with a report of discipline. If there really is an obligation, and in the case of Rule 8.3, it's mandatory if it rises to that level, you just have to do it. Next question is, how does this rule impact the rule requiring civility? Well, nothing is civil like nothing says civility like reporting or threatening your colleague to the state bar. But in this case, this is a mandatory rule. If there is a need to make a report, you have to do it. It's not a matter of civility or incivility. It's a legal requirement, and you're expected to do it. As I mentioned, there's a concern that this could lead to vindictive litigation games in mediation. I think that's kind of, as I mentioned, it does come up, but I think most lawyers know that's improper. But as I said, it does come up from time to time, and it's worth keeping in mind. And some of us as neutrals have to remind people that it's not, it's not proper to threaten someone with disciplinary or criminal action or criminal prosecution. And again, as we've covered fairly extensively this morning, the mediation, the confidentiality in mediation still applies. So in summary, this is a mandatory rule. It's not it's not voluntary. It's something that if the criteria are met, you need to do. And if you don't, you're subjecting yourself to discipline yourself. There is a knowledge requirement. It's not just a matter of a loose suspicion. It needs to be reported without undue delay. But in terms of the timing, while I don't know exactly how long you have, and I don't think it's set forth anywhere, it needs to be done, as they say, with all deliberate speed. And what I would say is you have time to consider it, and also to consult with your client in some cases. You also have to consider the impact to your client's interests. And there also is time, and I would highly recommend this in close cases or cases where you're not sure, to consult with an attorney who specializes in the area of professional responsibility or ethics. And those consultations are confidential and are protectable. To whom to report? To either the state bar or a tribunal that has the authority to take action. And as I mentioned, it does require some judgment. And finally, the mediation confidentiality and attorney-client privilege still apply. And also, I might have glossed over this earlier, if there's information that's learned in an attorney treatment and diversion program, that is also confidential and need not and should not be reported. And that is now the not so new but sort of new rule of professional conduct 8.3.
I did want to hop on here, Ed, and pitch one question that we had, a clarification question. Who determines in hindsight that an attorney should have been reported for specific misconduct? And who determines if the motive of the reporter was improper?
I believe the state bar. So either, reporting something carries a risk, not reporting something carries a risk. So that is important to not do it with an improper motive, and to make sure that what you're doing, you're documenting. And if you don't report something, you probably want to document it for yourself. And maybe in really close cases, as I mentioned, you probably want to get some professional advice to make sure that you're doing the right thing and not doing the wrong thing.
Great. I think we're ready to move on to the next section, unless Peter or Debra, you have any commentary on that new 8.3 reporting rule.
Nope, eager to start the next section.
Great. I'll turn it over to you, Debra, then.
All right, great. Well, we're in the home stretch, and I've been left with the section that, as we know, many high-profile lawyers have recently been in the news for client trust issues. That led to the creation of CTAP, Client Trust Protection Program. I think the more apt name for it probably is the Girardi CTAP program. And let's start out with a little background. So, Tom Girardi is a former plaintiff's attorney who gained fame with the Hinkley groundwater case, which led to a then record $333 million settlement and inspired the 2000 film starring Julia Roberts called Erin Brockovich. In more recent years, Girardi appeared a handful of times on Bravo's TV, The Real Housewives of Beverly Hills, starring his wife, a former waitress turned singer, Erica James. Girardi used to throw lavish holiday parties for attorneys and judges in Las Vegas. Judges and even the state bar may have been too cozy with Girardi. Some of his clients suffered serious physical injuries or lost loved ones as part of their cases, such as 20-year-old Joey Rui Gomez, whose girlfriend Jessica Morales died in the San Bruno pipeline explosion, which left him with severe all-over body burns necessitating a lifetime of skin grafts. Girardi lied to Joey Rui Gomez and told him the case settled for $7.25 million, when in reality, Girardi received a $53 million settlement. So during a mediation before two appellate justices, Girardi told the justices and his client, Joey Rui Gomez, and his parents that he had the best knowledge of how to invest the client funds, and he would rather do so rather than putting it into the hands of a structured settlement skilled personnel. What happened, I understand, is that Girardi stopped making some of the payments to Joey Rui Gomez, which led to the discovery that the money was gone. Girardi embezzled from clients who lost loved ones in the 2018 Lion Air plane crash. He embezzled from clients through a Ponzi scheme in which he misappropriated funds from some of his client settlements to pay off their other settlements. So this led to the creation of the Committee on Special Discipline Case Audit in mid-2021, and then within a year, we have CTAP. The goal is to proactively regulate client trust accounts and help quickly identify attorneys with issues, including willful non-compliance. It went into effect December 1, 2022, as part of the 2023 license renewal process after approval by the California Supreme Court. So, as we know, next slide, please. Lawyers have statutory and ethical obligations to safeguard funds they hold for their clients, and we know we put those into the client trust accounts. Next slide. So the CTAP requirements, basically all attorneys in good standing, including some of us mediators, if we have the client trust accounts open, must comply with new requirements, including registering your client trust accounts, including your IOTA account, annually with the state bar, completing an annual self-assessment of client trust account management practices, and certifying to the state bar that you understand and follow all requirements and prohibitions pursuant to Rule 1.15 of the Rules of Professional Conduct. You may fulfill your reporting requirements through My State Bar profile. So if you were trying to prepay your state bar dues, as you might do at the end of 2024, you learned that you couldn't do so. Instead, you have to do so by the 2025 annual deadline of April 1st, because you have to comply with these various reporting requirements that pertain to CTAP. Penalties have been imposed as of April 2, 2023. To register, including your trust account, you must report your year-end balance. So penalties. Your failure to comply results in a non-compliance penalty, and that can include, if you continue to be non-compliant, the attorney will be enrolled as an inactive licensee. So that is really the penalty. You will go from an active to an inactive status. I'm going to skip the CTAP requirements on the next slide, which are in your materials, just in the interest of time. And I'll get to the self-assessment. So that pertains to almost everybody who is listening. Basically, a subordinate lawyer in your office may consult a supervisory lawyer to confirm the duties are performed by others at the firm. In other words, lawyers at the firm must actively monitor the trust accounts of clients that they manage. And you are entitled to rely on your supervisory lawyer's responses. The objective of the self-assessment is to promote awareness of the duties, and there are no exceptions for out-of-state accounts. So what do you do if you discover potential non-compliance? There are some red flags. Historical unreconciled differences in bank accounts, negative client balances, excessive dates of the last transaction, for example, 45 days for settled accounts that are still in the trust account, large balances in the IOTA account, and excessively aged outstanding checks. So when you see these red flags, you should consult with your CPA, your ethics attorney, and perhaps outside experts as soon as possible. Let's go to future enhancements, please. So in the future, the bar will expand public outreach and education. They will enhance education for attorneys and compliance reviews of selected attorneys by CPAs. Next slide, please. There's also a pro bono reporting requirement. So for active attorneys who are gracious enough to do pro bono in our community, this new California law applies to you, and you will also have to report your pro bono services. So the key definition, pro bono legal services means they're free legal services to indigent individuals or qualifying organizations. Reduced fee legal services are when there are substantially reduced rate legal services for low-income clients or organizations. Next slide. So the reporting requirements. Who must report? All active state bar licensee throughout their My State Bar online profile. The information to be reported every year when paying your license fees will be your pro bono hours for last year and your reduced fee hours. There are exemptions. For example, if you're a full-time employee of an organization primarily providing pro bono legal services, a government employee, or attorneys prohibited by employers from performing pro bono work. Next slide. The State Bar will keep reported data confidential and exempt from public record requests. Failure to report is not grounds for disciplinary action. What we've discussed is that you'll be moved from active to inactive status. And the State Bar will maintain records for 5 years. So that, in a nutshell, are the now more, I guess, onerous reporting requirements due to many high-profile attorneys, including Girardi, that you misused or misappropriated their client trust accounts. Thank you, Katie.
Thank you, Debra. I'd like to move right along to the next and final section, and if we have any time for questions at the end, we will address those. But thanks so much, Debra. All right, Ed, I'm handing it over to you here, though you are on mute right now.
Okay, I don't know what I did to ADR Services to get the slot between right before lunch, but I must have done something. So I'll try to get through this quickly. So we were talking about increased regulation. So now there's increased regulation of neutrals and ADR providers in the form of Senate Bill 940, which just took effect January 1st, 2025. This was sponsored by State Senator Tom Umberg. And again, this was inspired by the criminal conduct and misconduct of Tom Girardi that Debra went through with us. In a recent interview with the Daily Journal, Tom Umberg said that for the first time in his career, constituents are regularly asking him about state bar matters and attorneys. So that is part of the impetus for the increased regulation. So Senate Bill 940 now does the following things. The State Bar is creating a voluntary certification program for neutral providers. There are now restrictions on the location and applicable law for consumer arbitrations. Consumers have the option to go to small claims court in cases where small claims court is that their case qualifies for that. There's a requirement for the disclosure of solicitation by ADR service providers and neutrals, and there are solicitations that are prohibited during the pendency of a consumer arbitration. And there's also now expanded discovery in arbitration. Next slide, please. So this gives an overview of the new ADR certification program. It's voluntary, but it requires certain things in order to get certified as by the State Bar, including having a department within an ADR firm where people can make complaints, and a mechanism or a procedure to deal with the failures of arbitrators or mediators to comply with the standards that in order to be qualified or certified, the ADR firms need to make sure that their neutrals are following the ethical standards that are set forth in the Code of Civil Procedure. And one last point, that's okay to keep it at this slide, but this doesn't just apply to licensees of the State Bar. Someone who is not a licensee of the State Bar is also subject to these to this program. So there are now restrictions on the location and the applicable law for consumer arbitrations. As of the first of the year, an arbitration provision cannot require a consumer to arbitrate outside of California a claim that arises inside of California, and also cannot require arbitrating a controversy that arises in California under the substantive law of a state other than California. This does not only apply to California residents, and it also applies to claims arising from activities in California regardless of residence. a provision that violates this is voidable by the consumer, and if it's rendered void, the matter needs to be litigated in California, and the law of California governs the dispute. And there's injunctive relief and other remedies and attorney's fees that are available to enforce these rights. There's a new option of going to small claims court for a consumer that is otherwise subject to arbitration. The matter would have to qualify for small claims court. The jurisdictional amounts would still apply. The statute does not specify, however, who is required to give notice to proceed in small claims court, whether that's the arbitrator or somebody else. But it applies to any contract that's entered into, modified, or extended on or after January 1st of 2025. So now there are requirements for ADR services and neutrals to require solicitations. There are, if there is in a consumer proceeding, there's now Code of Civil Procedure section 1281.9, which has been amended to add subdivisions A7 and C4, which requires a proposed neutral to disclose in any consumer arbitration a solicitation made after January 1st, 2025, and within the last 2 years, at the direction of the private arbitration company to a party or a lawyer for a party to the consumer arbitration. So a solicitation is defined as made to a party or a lawyer for a party by the private arbitration company or the arbitrator, and oral or written discussions, meetings, or negotiations to designate the private arbitration company or the arbitrator as the arbitration provider for a party in specific contracts. Solicitation does not include 4 different types of communication and activity, and those are advertising that's directed to the general public, communications indicating a general willingness to serve as an arbitrator or private arbitration company, presentations made by the private arbitration company or arbitrator at a program or seminar held to the public, I guess, such as this, or responding to inquiries regarding the arbitration provider's costs, rules, procedures, or standards. There's a prohibition on solicitation during the pendency of a consumer arbitration, and the solicitation has the same meaning as defined in Code of Civil Procedure 1281.9 that I previously mentioned. There are also some expanded discovery rights in arbitration. Prior to January 1st, 2025, full discovery rights were only available in certain types of cases under CCP 1283.5, such as wrongful death cases. Now that's been expanded to include all cases that are in arbitration. There are more fulsome availability for depositions, not just in those cases that were covered by 1283.05 that I mentioned before, and the request for deposition should go through the arbitrator, but the arbitrator is permitted to grant those requests. And there are also requirements or further availability for third-party subpoenas that basically track the expansion of discovery rights that I just mentioned. So I think that's the overview of Senate Bill 940, and I think that leaves us with 5 minutes in the program for any questions about anything that we've covered this morning.
It certainly does. Thank you so much, Ed, for going through those new options there. Before I pitch some questions, Debra or Peter, did you have any thoughts or closing things to share about Ed's last comments?
It's all too new, and I think we're all trying to digest it.
Mm-hmm. Yes, I do know that the State Bar is establishing a working group to build the certification program, which will begin meeting in late January and continue meeting monthly. Those meetings will be open to the public if you'd like to follow along and watch as the programs meet or as the working group meets. So that is something that is going to be actively underway with the State Bar. And of course, we will be interested to see what the result is and what that certification process entails. We do have a couple of questions here, harkening back to some other portions of the program. We did have a bit of a clarification as far as the pro bono reporting. Debra, is it accurate to say that there's not a pro bono requirement for attorneys, but just if they do pro bono work, now they're encouraged to report that? Oh, we lost your audio. I'm so sorry, Debra.
Oh, I was on mute. But that is correct. And I would like to comment about, all these new programs I'm putting in place. I did read one of the questions which said, do bad facts make bad law? And I will say that, the extremely egregious conduct of misappropriation of funds, I think they were in the triple digit millions by Tom Girardi, has left all of us now with these reporting requirements for our client trust account that I believe most of us conscientious attorneys are on top of, anyhow. And also, is this a deterrent to doing pro bono hours? Since now you've got the extra obligation of reporting the hours in which you are spending your time volunteering. So it kind of reminds me, I don't know if there's a bad correlation, the Unabomber case when, because one person thought to take off her shoe to create a bomb, then all of us going through, right, TSA then had to take off our shoes as if this was now the way that they were going to protect us. So it'll be interesting to see how they do this, but I agree with the person who commented that sometimes bad facts make bad law. And I know I'm disgruntled about having to go through the onerous steps as well.
Mm-hmm. Something pulling back to one of the earlier sections about confidentiality, I believe. Excuse me. Sorry. If somebody is sharing an expert draft report for the purpose of mediation, can they then ask for the draft to be produced as part of the expert file? Kind of going back to Peter on the confidentiality things.
Ordinarily, in the statute, the expert has to provide all reports, including all draft reports and that sort of thing. So that at the appropriate time, it wouldn't necessarily be after the mediation. It would be probably closer in time to trial. Hopefully the case settles before then, so it does become an issue. But yeah, all draft forms would have to be produced.
Yeah, but the more interesting question, Peter, would be if the attorney is aware of this draft and when the expert produces his or her file and it doesn't contain that particular draft, then what do you do for impeachment purposes? And I think, unfortunately, that's one of those quagmires where if it was produced in mediation, you can't really question upon it, even though you know that it exists.
Yeah.
That pulls back to another question we have. What are the consequences under 1119 if somebody shares things learned in mediation that have not been obtained through formal discovery?
1119 doesn't speak to it. So
I do not know.
So I think that the answer would be that there's clever ways of trying to get information that's learned in a mediation by way of, say, follow-up interrogatories and that sort of thing. The problem, though, is you can't necessarily ask for, hey, in mediation, you produce X number of these documents, please produce them, or whatever it may be. It has to be a little more careful than that. Your remedy, I don't know, is not a motion to compel, because if the information for the basis of the motion is that you learned it in mediation, it's not going to become that will not support the motion.
And one final question I wanted us to end on was, how often do mediators' proposals actually work?
I saw that one. I only know from my own experience that I would say the majority have worked. There might be one or two that didn't. And I will say that they were probably my fault, that I didn't read the tea leaves well, or I wanted to stretch too much for the plaintiff's counsel, which then puts their client at disadvantage if it wouldn't get it settled. So I don't know, at least me as a mediator, I'm constantly learning, and I don't put myself in that position anymore. But I'd say 98% worked for me. Ed, what do you think?
I think they mostly work for me because I kind of prep the battlefield before I do it, and I'm only using them in the instances where I think there's a good chance that it will succeed.
Likewise, I only do it if I know that it's going to succeed, and that usually requires plowing a lot of road before I get there.
ADR Services, Inc. has been your unwavering partner in alternative dispute resolution. But as the world changed, so did we. From virtual and hybrid hearings to our ongoing on-demand CLE program, ADR Services, Inc. continues to keep resolution and legal education at the forefront, woman-owned and operated from the start. There is someone for every situation. We are ADR Services, Inc.